everyone, this is Tracy Chen, and today I want to talk about the direct entry 186 employer sponsored visa. Now, you may have seen in my previous videos, I talked about the 186 temporary residence transition stream, and it's a little bit different to the direct entry stream. This one is direct entry, as the name suggests. For those of you who don't know me, my name is Tracy Chen and I'm an immigration lawyer based in Australia. We help visa applicants with all sorts of visas to Australia. If you want to get in contact with myself or one of our fantastic lawyers or agents, our details are linked below. Now, before I jump into this video, don't forget to like and subscribe and share this with people who need it. The 186 direct entry visa. This is a permanent visa, and today I will discuss the eligibility requirements, but it will be a very basic overview. So if this is something that you are looking to apply for, make sure you get in touch with your migration lawyer or agent so they can provide you more in-depth advice. So first of all, to be eligible for this visa, you need to have an eligible sponsor. So you need to find an employer who's willing to sponsor you in an eligible occupation for this visa. Now, an eligible occupation is an occupation under the medium to long-term strategic skills list. So this would include occupations such as chef, software engineer, carpenter, registered nurse, and even management consultant. This does not include all the other occupations on the short-term and regional occupation list. So examples would be your enrolled nurse, your cook, recruitment consultant, marketing specialist. You can't be sponsored under the 186 direct entry stream. You would need to consider the 186 under the temporary residence transition stream. So your employer does not need to be registered as a standard business sponsor for this. I know in my previous videos for the 482 and the 186 under the TRT stream, I mentioned that there must be a standard business sponsor. However, for the direct entry visa, they do not need to be. They just need to nominate you and then you need to apply for the visa. That's it. So you don't really need to do labor market testing in this situation. Sometimes we still do it, just depending on the occupation and when we've assessed things about the company. But overall, labor market testing is not a requirement. So say, for example, you've been working for your employer for a while and you want to be sponsored for permanent residency in Australia. Let's take solicitor, for example. So solicitors can be sponsored in Australia, and to be eligible for this visa, you must have at least 3 years of full-time work experience at the required level. Now, we interpret this to be post-qualification. A lot of people say, where does it say post-qualification? Well, it doesn't. But at the required level, you would assume that you have the relevant qualifications. So 3 years of full-time work experience after that. So for example, if you are looking to be sponsored as a chef, you would need to have a minimum of diploma of hospitality and then 3 years of full-time work experience after that. Or if you are an accountant, you would need to have a Bachelor of Accounting and then 3 years of full-time work experience as an accountant after you completed your bachelor's degree. So now that we've identified the occupation, the employer will nominate you. They'll need to provide you with the employment. So you need to provide evidence of an employment contract, and that salary needs to be a minimum of $73,150 or the market salary rate. So for example, a lawyer who has 3 years of post-qualification work experience, your salary would most probably be higher than $73,150. You would need to conduct a market salary report to ensure you have the right salary, because that can result in a refusal as well. So don't just go by what the minimum says, which is $73,150. And a lot of the time, the employer will also need to prove that there's a genuine need. So it's probably more important for direct entry. It's important for all the employer-sponsored visas, but particularly important for direct entry because the department is going to be more strict on this because you are being sponsored for permanent residents. So they're probably more stringent in the way that they are assessing these applications. So you need to show that the business is expanding, they're unable to fill your position with someone from Australia. So that's what you'll be looking for. You also need to be careful of the caveats on certain occupations. Like for example, if you're an accountant, you need to have a minimum of 5 employees and it can't be low skilled tasks. It has to be an accounting role. And this is where it gets really tricky when I try to explain this to clients. So for example, I had someone come to me and it was a marketing agency with 6 employees and they wanted to sponsor an accountant. And I said to them, look, I think their turnover was like 1.2 or 1.3 million. And I was telling them, look, you can do it, but it's going to be hard to justify why you need to hire an in-house accountant. Because you think about it, the role that an in-house accountant does, it's pretty high level. And even though you meet the minimum caveats, you still need to be able to prove that there's a genuine need. So a business with 6 employees, $1.2 million turnover, the department's going to look at that and be like, do they really need an internal accountant? I mean, I look at my business, for example, we have almost 70 employees. And I don't have an internal accountant. I have an external accountant, which we pay, a substantial amount, but it wouldn't be as much as you would pay an internal accountant. You'd really have to have a lot of work for them to be able to substantiate the costs and justify why you need them. So that's one of the really important things. Now for us, we're a law firm. So if I wanted to sponsor a solicitor on a 186, that'd be pretty easy to prove. As long as my business can afford to sponsor them and pay them, I can definitely justify that. Even if I wanted to hire like a marketing specialist, that may be difficult as well. Because again, why would I need a full-time marketing specialist? Do I really need one? Or can I hire one externally? Those are the things that the department is going to look at. This is something that I'm always trying to communicate to our clients. Let's just say we've got that part down pat. Then we look at your visa application. So with the 186, you need to have a full skills assessment. And this makes it slightly trickier than the 186 under the temporary residence transition stream. So some occupations are easy to get a skills assessment, like accountant or perhaps even registered nurse, as long as you have the ARPA registration. But for some occupations, it's a little bit harder, and that's something that you need to think about. You'll need to meet the English requirements, which is if you're doing IELTS, it will be 6 each in each band. You need to prove that you have the qualifications plus 3 years of full-time work experience. Work experience can be used in lieu of qualifications if the occupation code allows it. So you'll need to check as per ANSCO, and this is definitely something you need to get the right legal advice. Because if ANSCO, for example, says for a chef, in lieu of having a diploma, they will accept 3 years full-time work experience. But that means if you're going for the 186 direct entry, you need to have 3 years of full-time work experience to qualify for the qualifications. And then you need to have another 3 years after that to qualify for the 186. So as you can see, in total, you need 6 years there. So it gets a little bit confusing, and this is definitely not something I would take lightly. It's something that you need to assess with your migration lawyer or agent. And for us, we even sometimes, if we're so unsure, we would conduct an eligibility assessment first. So we would actually grab a copy of all the applicants' qualifications, pay slips and all that to make sure they actually have the 3 years work experience, because a lot of people do say, yeah, I've got 3 years. But sometime in year 2, they took 2 weeks of unpaid leave or something like that, or they changed jobs and they were in between jobs and they weren't working for 3 weeks, things like that. It's actually really important to check, because the department is going to be checking that with a fine-tooth comb. Now again, as this is permanent residency, your spouse may be required to meet the English language requirements. You may be exempt for certain passport holders, and it's a requirement at time of decision. And if your spouse really cannot score the English, you can pay. So you pay the second VAC payment, I think it's called. And basically you're paying because you don't have the English. But the English requirement's not high for the spouse, it's functional English. So it's like 4.5 in each band for IELTS. If your spouse does not score this and still wants to be part of the visa application, then I think the fee is like almost $5,000. You'll need to check, because that number goes up all the time. So if they can get functional English, I highly recommend they go for it, because they'll save a substantial amount of money. Now, the processing time of this visa really does vary. So it could be 3 months, up to 12 months, or sometimes even longer. But look, it's a great visa, and if you meet the requirements across all aspects, you should be getting a visa grant. But again, you need to be very careful, especially on the things of like genuine need and stuff that I spoke about. But yeah, I highly recommend this. Open the discussion with your employer if this is something you think you qualify for or may qualify for soon. Anyway, thank you so much for watching. Now, I hope you guys found this video useful. Don't forget to like and subscribe and share this with people who need it.